Even illegal aliens who are not Tren De Aragua don't get appointed ACLU lawyers. And so this theme we've been on, it's not due process, it's due process plus. It's double due process, baby, because they're illegal and they're now better than you. So for you, judge, to come in here and to say, actually, you know, the Tren De Aragua is not a gangbanging organization that's connected to Maduro, you don't get to make that judgment by statute.
And each and every one of you that sides over and over again with these MS-13 terrorists, to the extent that you have the financial means to do so, you all choose to live in condos or homes or houses as far away from these kinds of gangbangers as you possibly can.
Judge Fernando Rodriguez Jr. now appointing the ACLU to represent illegal gangbang and Tren De Aragua individuals who should be deported out of our country. We've got several orders that are coming out of Texas, and this one's pretty surprising. And this dude is a Trump appointee. So you're going to hear a lot of that in the headlines. A Trump appointee is now undermining President Trump and attacking his own unconstitutionality, blah, 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 right? It's covered because he's a conservative type of judge. But you'll just read through this order, and in particular, this final paragraph where it says that this judge, Rodriguez, is ordering that Lee Gallant of the ACLU is appointed lead counsel for a class action of gang members who have been subjected to the Alien Enemies Act proclamation and ordered to be deported, now have ACLU appointed lawyers. And all ACLU attorneys who have appeared in this matter are also co-counsel for the certified class. Wild times. So, just to be clear, most illegal aliens don't get appointed ACLU gangbang lawyers, but the Tren De Aragua people do. So most illegals, even all the illegals that were deported under Joe Biden and Barack Obama, they didn't get appointed ACLU lawyers. Trump comes in here, and now the judge is giving people who've already been identified, as we saw in the Kilmar case, and there have been judicial findings on this, when they say, well, no judge has found he's MS-13. Yes, they did. They wrote it in multiple orders. The appeals court listened to it and validated it and said there was no abuse of discretion or clear factual errors and validated it. It's in the judicial findings. Judges found it. You don't need to have another trial on that to determine whether he's MS-13 or have a jury and a whole presentation about it. It's been determined. He's an illegal immigrant. He's not a citizen in a country. He doesn't get access to Article 3 courts like every other illegal before him doesn't get access to the Article 3 courts unless they file a petition for habeas, which we'll talk about later. But this dude now is being appointed not only for illegals, but for Tren De Aragua terroristic illegals, like the worst of the worst of the worst. They got ACLU lawyers appointed to them. Now, this came from this guy, Judge Fernando Rodriguez. He's out of Texas. He came from Yale, typical. And for a while, he was working with the Associate Justice of the Supreme Court of Texas. He was ultimately appointed by Trump, saying Trump nominated him in 2017. He was elevated to the position in the Southern District of Texas. Had a hearing, voted 94-1, confirmed 96-0, and he's also on a list of Hispanic and Latino American jurists. And so the obvious thing that people will point out there is to say, well, he's a Hispanic Latino person. And it sounds like this ruling is very favorable to a group of people who are also of that same persuasion, right? Kind of hard not to notice that. Call me a bigot, xenophobic, whatever, but got to notice that. And you see that is happening in this case, right? So that is Fernando Rodriguez. Now we have 3 orders that came down from him. So the first one that I just wanted to share with you was where we kind of finished at the end, and we'll rewind here, but he's certifying a class action of these people. So the original lawsuit was JAV and just a few other people who sued. So example, JAV, JGG, and WGH. Okay, these are initials for gangbangers, according to the Trump administration, who's identified them. And just like we saw, they don't need to have new trials for these people. It's already been found, as in the Kilmar case. But if they want to challenge it, they can file a petition for habeas in federal court. So these 3 are under that category, right? And now they say that Trump is attempting to remove them out of here under the Alien Enemies Act that was invoked to get rid of Tren De Aragua people, where there's already been adjudications on this. Saying simultaneous to this, okay, they filed a habeas action. They also are trying to certify a class. And this is something that the Trump administration has always been in favor of. And they've always been allowed to file this petition. They never wanted to do that because they're filing them as pseudo-constitutional claims to get the class actions and to get nationwide injunctions when they file these in front of Judge Boasberg or in front of Judge Zenas or in front of Judge Amy Berman Jackson, or pick any of them. But here they go to this judge and now they want to certify an entire class. He says, yep, it's appropriate to do that. I think it's appropriate. So they're all going to be certified as a class. Petitioners are asking the court, the ACLU, to certify a class. And Trump says you can't do that. There's no basis to certify a class and to undermine the power that Trump has to articulate who has invaded our country. They say the Fifth Circuit and the Supreme Court have never explicitly ruled that class actions are a proper mechanism in habeas corpus actions, right? So if you're challenging your removal, your right to be removed, the Supreme Court has never said you can apply that to everybody, but they're doing it for the first time now because with Trump, everything's brand new. They just shatter precedents like arresting him or rather invading his house and his wife's closet. But that said, the Supreme Court has reviewed cases and saying they haven't said that we can't do it. Okay, other circuits have addressed this. So can I certify a class of gangbangers? Well, the Supreme Court hasn't said we can't. In 1974, the Second Circuit was talking about this. In this other case, the Seventh Circuit was talking about this and blah, blah, blah. So in response to this, we're going to go ahead and find that they are a class. There's commonality. They're all gangbangers and the present matter raises many questions of law, blah, blah, blah. So this is a class action order right now. At the end of the order, he says, boom, we're going to find that they are a class. Here's the official class. Here's the bucket of these people. It's going to be Venezuelan aliens, 14 years or older, who have not been naturalized, who Trump has designated or in the future designates as an alien enemy under the presidential proclamation, who are detained or reside in the Southern District of Texas. Okay, so it's bucket, it's limited, cabined to this, only this one district. It's not nationwide because the judge is saying, well, I don't have nationwide jurisdiction. So at least there's that, but he's still issuing a class action for gangbangers in that district. So Fernando Rodriguez is saying they get lawyers. They get ACLU lawyers appointed to Tren De Aragua, and that's just the beginning of it. So here is where the rest of his order comes down. Capturing a lot of attention today, saying on March 15, 2025, Trump issued a proclamation. This is the background for his opinion appointing lawyers for gangbangers. Even illegal aliens who are not Tren De Aragua don't get appointed ACLU lawyers. And so this theme we've been on, it's not due process, it's due process plus. It's double due process, baby, because they're illegal and they're now better than you. You don't even get that much protection. Do you get ACLU lawyers appointed for you? Anything that you've ever done in your whole life as a judge come out and said the ACLU is going to protect you when that cop did that thing that was bad to you? Or when you were a J6er and your house was raided by lunatic feds? No. Or when you're a parent showing up at school board meetings and the FBI was surveilling you? Where was the ACLU for that? Nowhere, because they're basically foreign operatives at this point. It says Trump issued a proclamation invoking the Alien Enemies Act to get rid of these monsters out of our country. Now, under the authority of the AEA, the president proclaimed that all gangbangers gotta go. So these three petitioners are natives of Venezuela. Okay, they're currently detained in Texas. They bring this action under U.S. code saying, we have been denied our due process rights under the Fifth Amendment to the Constitution. It's a habeas petition. Now, they say that Trump can invoke the AEA under the alleged circumstances. First of all, they say he can't do that, right? Can't even invoke the AEA because Tren De Aragua doesn't qualify as a category that's covered under the statute. And also they say we're not even Tren De Aragua. So the statute can't apply to us and we're not gangbangers anyways. So they bring this suit individually and as a class action in Texas, same judge. Neither the court nor the parties question the executive authority or the responsibility to enforce the laws, right? Nobody's challenging Trump. Nobody's saying that they can't follow the laws. But the question this lawsuit presents is whether the president can use the AEA to remove these people who are members of TDA. And as to that question, the historical record renders clear that the invocation of the AEA in the proclamation exceeds the scope of the statute. We called this out months ago. I think it's their best argument. Now, as a result, the court concludes as a matter of law that Trump's proclamation is unlawful. He cannot rely on the Alien Enemies Act to detain these people or to remove them from the country. Now, they're going to give us some background on here. Here's what the judge says. 1798, there was a war with France. They talked about the AEA. Oh, AEA was at the center of the lawsuit, right? We've read it here before. Predatory incursion, invasion. But what they'll say is it's about foreign nations, right? And even in Trump's proclamation, he made the argument that Tren De Aragua was essentially an extension of the Maduro regime in Venezuela, and that therefore they are an extension of the nation state, right? So the AEA grants broad powers, and once properly invoked, Trump can do certain things. Now, before this year, they say 3 wars is where this has been invoked. War of 1812, right? As we mentioned before, the British and the Irish. More than a century later, World War I, Woodrow Wilson invoked it, and then FDR. Now, let's see if he talks about how this was used. He made a public proclamation saying enemy of Japan. Yeah, and that history is a lot more complicated than that little paragraph here. Yeah, here we go. In 1945, after the Axis powers in Europe had unconditionally surrendered, Truman issued an amended proclamation that permitted the removal of Japanese, German, Italian, Bulgarian, Hungarian, Romanians, that anybody the Attorney General deemed to be dangerous and to be the subject to threats and safety, right? And so, yes, FDR used the Alien Enemies Act expansively, massively. He used it to imprison our own citizens, for crying out loud. So for us to say now, or for the left to say now, that Trump can't act under the similar powers to get rid of illegal aliens who have no right to be here in the first place, who have indicia of criminality, that he can't have that same power? Venezuela and Tren De Aragua, they say, okay, in 2011, Barack Obama issued an executive order to block property ownership by transnational organizations. He used Code of Federal Regulations. The Treasury Department also designated this. Yeah, and also Obama, it's interesting. Obama also took out that one American citizen called Aliki, I think was his name. And there was no due process for that dude either. They just kind of talked about that. No judge, in other words, signed off on a death sentence for that person. And they targeted him. It wasn't like, oh, accidentally, it was a mistake of war. Like, oh, no, we're going to go take that dude out, and just took him out. So was that allowed under any of this? Like, is he going to talk about that in due process? Was that under the Alien Enemies Act? I don't know what authority that was. But Obama declared that these people were dangerous. The Treasury Department went after this dude. In July 2024, Tren De Aragua was placed on a sanctions list. In 2024, Interpol captured another high-ranking member of TDA. These are bad dudes. So then in March, Trump issued the proclamation, right, saying Tren De Aragua infiltrated the Maduro regime and the Venezuelan presidency, essentially. And so therefore, I declare that they are perpetrating a predatory incursion and an invasion of America. Now, let's take a look at these petitioners who are probably just makeup artists from San Francisco here for a better life. So this person called Jav is a Venezuelan national. February 2025, not long ago, he was arrested at his asylum interview, because that's what they all claim. I'm here claiming asylum. No. When questioned, he denied membership at TDA. ICE initially detained this person in Venezuela, and then, like I suspected earlier, sent him over to Texas, which is why this order's big, right? They round him up, send him there. Then he was informed he would be removed within the next 2 days, 48 hours. That's plenty of notice. So then this other person, JGG, he said he came in, he has to escape torture in Venezuela. I know, lots of tortures. I don't know if he had a pupusa business down there either, like Kilmar's pupusa business, which he was under torture for there, as we recall. So he was so heroic and such a brave person, he fled his family who was under attack to come up here and beat his wife. On March 6, he was transferred from California to El Valle in Texas, and then the respondents attempted to remove him, but the plane did not depart. So that might be the same JGG in the Boasberg case. Then we got this other Venezuelan national who lived in Brooklyn with his wife and stepdaughter. ICE arrested him. March 7th, filed a form with the immigration court identifying him as a gang associate. Then 3 days later, he was transferred. They said, you're also out of here March 15th or 16th. So bye. So then they sued. So the petitioners, along with 2 other people, sued. They sued in Washington, D.C. because that's where their home field advantage is. They could sue in Texas. They could have sued in Texas from the beginning, in part under the APA, which is a fake claim. After the court issued a TRO, that was Boasberg, the respondents appealed and the matter reached the nation's high court. Yeah, so Boasberg, right, didn't have jurisdiction on this, so they're kind of still processing it over here. On April 7th, the Supreme Court temporarily resolved Boasberg's crap TRO that was illegal, where he ordered Trump to turn the planes around. That was that judge, reasoning that the petitioner's claims for relief necessarily imply the invalidity of their confinement, and you gotta bring it in habeas, right, in Texas. Now, on April 9th, then they filed their writ of habeas corpus in Texas, which is what they should have done in the beginning. They challenged their ability to remove them, and they say, we're not members of Tren De Aragua, and you can't invoke it against us anyways. The court extended the temporary restraining order, saying you're not going to remove these specific people, and we had a bunch of hearings. We notified the parties that we're going to have hearings on May 1st, 2025, which is today. The court granted the class certification. We just read that in the previous filing. Certified a whole class of gangbangers, gave them ACLU lawyers too, and gave us the explanation for that, which is outstanding. So they get more representation than you would if you were charged with a crime. Now, analysis. They say that these gangbangers are now seeking relief by challenging Trump's proclamation, saying, we're not doing a predatory incursion in your country. It's hilarious. So like, this is not a predatory invasion. We're like, where are you seated right now? Are you in America? Yeah. Are you allowed to be here? No. Did anybody invite you in here? No. Did you come here lawfully? No. Did you apply for asylum when you got here? No. Did you come in at a port of entry? No. Did you register? No. Well, what the hell is that? If not a predatory incursion? You're here illegally. It's by definition, you're part of the lawsuit, suing in our courts, inside the country. You've incurred, okay? You've invaded. You're here. Says, and third, petitioners claim that the proclamation violates specific protections that Congress has established for non-citizens seeking humanitarian protection. I know, because their little pupusas are getting obliviated down there in their home countries. And the point is, they should stay in their home countries and fix the pupusa attacks that are happening there. Okay, we can't be your little pupusa escape valve here. Respondents contest the validity, and so they're going to say, here's the question. First of all, what's the appropriate standard? Well, they're bringing their actions in habeas, and they're not seeking release of detention. They just don't want to be removed to those other countries. Now, Trump says, first of all, you can't even challenge this this, Judge. Are you nuts? The statutes say you can't challenge this. It's not ripe or proper for judicial scrutiny. How dare you substitute your judgment for mine? I'm the president. The American people elected me to sit in this position, to hear from all my cabinet members, to hear from Homeland, to hear from DOJ, FBI, Cash, and the rest of everybody else, to get my bearing straight on what's happening. And I've been empowered to make decisions based on that information. That's how the system works. So for you, Judge, to come in here and to say, actually, the Tren De Aragua is not a gangbanging organization that's connected to Maduro, you don't get to make that judgment by statute. Repeatedly, this judge is mad. They claim, Judge Rodriguez, obviously, whether the AEA's preconditions are satisfied is a political question committed to the president's discretion. In both instances, they rely on substantive case law describing the broad powers that Trump has as president. Now, they respond, the other gangbangers, they say, Your Honor, kind of. Like, it is kind of a political question. They're even admitting it. But this is a narrow exception to this because it's not going to undermine authority because the statute is illegal. Basically, how he's being used is illegal. They also say that Judge Kavanaugh had some stuff to say about this, and the Supreme Court's talked about it before. In fact, in 1827, they did something, and they rejected that. And then in this other Martin case, they rejected that. A century later then, in World War II, the Supreme Court considered challenges concerning the Alien Enemies Act, right? We remember these cases, the Ludecky case, the Johnson case, maybe they'll get into Korematsu up here. Let's see. Says in at least two of those cases, the nation's high court recognized the broad powers that the AEA placed in the president. They wrote this. The Supreme Court said, the very nature of the president's power to order the removal of all alien enemies rejects the notions that courts may pass judgment upon his discretion. You can't substitute the judge and their opinion for the president's opinion. Otherwise, the judge is the president. Writing, executive power over enemy aliens, undelayed, unhampered by litigation, has been deemed throughout our history essential to wartime security. Now, in those decisions, the Supreme Court also identified issues related to this that are subject to adjudication. They say you could go to the court, you could ask about interpretation and constitutionality, right? So the judge is then going to come back and say, okay, what I can, even though you said I can if it relates to these things. Okay, so these are the things that I can talk about. Whether there's a commitment to another coordinate political department, lack of judicially discoverable standards and other things, right? These are other things that are not actually political questions, that are not me substituting my judgment by law. There are a couple areas that I can't go into, but in these areas I can. Now, the Supreme Court said in the Boasberg case, says this role is not surprising, and writing, many others have construed the AEA, and there are questions about what does native or citizen mean, and there's other questions about what invasion and predatory incursion means. Now, as a corollary, right, in kind of the opposite of a lot of that, or in complement to that, the corollary is that the court concludes that a presidential declaration invoking the AEA must include sufficient factual statements. So you got to prove it to me that it's good enough, or I'm not going to accept your homework. This isn't really alien enemies. Because you got to enable a court to determine whether you can invoke the statute. So it's got to be factual enough that I get to approve your action as the president of the United States. It's like such a wild shifting of the balance of power. You got to make sure you can do it. It's approval. Congress wrote in the statute, it's not subject to your judicial review, saying the president cannot summarily declare that a foreign nation or government has threatened or perpetrated an invasion or predatory incursion, followed by the identification of the aliens subject to detention or removal. This is the Fifth Circuit in 2024 from another case. So saying if you just allow him to unilaterally define the conditions, then it would remove all limitations. It would strip the courts of their traditional role of interpreting these things. So of course, if he says it's this, then we can check it. Now, the court is mindful that Trump may possess sensitive and confidential information, obviously, leading to its conclusion that a foreign nation or government is attempting a predatory incursion. But this possibility does not require the conclusion that the AEA is an exception, that we can say whether you've exceeded the scope of a law. So we can, of course, do that, says the judge. And while the president's declaration invoking the AEA doesn't need to disclose everything, it does need to sufficiently identify information that would allow us to review your homework so we can determine whether there is an incursion or not. Now, having concluded that I can hear this, I'm going to turn to what I'm allowed to question you about. Now, the ACLU gangbangers lawyers say, you're not giving the gangbangers enough notice and due process, not enough. And so basically notice is a component of due process. Do you have notice to appear? That is a component of due process. Respondents emphasize that the notice and the challenges are moot. They say, we're not going to move these people out of here anyways. But he says, but not about the class, right? So Trump says, we're not deporting these people. They got notice. They filed their habeas. We're not going to move them. But the judge says, I, Judge Rodriguez, am going to make sure that the rest rest of the illegals also stay in the country. And as they know, finally, the court says, neither the AEA nor due process requires that they afford them an opportunity to voluntarily depart either. So they then challenge the invocation of the Alien Enemies Act. So the gangbanger lawyers are coming here saying, we're just going to interpret the statute and read it on its face to see what it means. What does the statute say? So the judge is going to look to multiple definitions, going to go to dictionaries, essentially, multiple dictionary meanings. The historical context is relevant, but doesn't dictate the word's meaning. So I'm just going to look to the definition. He says, to apply the principle of looking at definitions, let's look at the words. Now, the proclamation invokes the AEA by saying Tren De Aragua is perpetrating or causing an invasion or predatory incursion. And they say that's all we need. We've invoked it. In support of this reading, they say, the gangbangers, that no president has invoked the AEA other than during a time of war, right? So it's got to be in a declared conflict. 1812, World War I, World War II. Now, based on their proposed construction, they say that Tren De Aragua in Venezuela, it can't be that because we're not in a declared war. But Trump says we got to read that much more broadly. And this is where that terrorism case law comes into play, right? We're kind of in a declared war on terrorism. That's an amorphous term. How do you ever defeat that? What is a predatory incursion? What is a hostile entrance? They say it's much broader, but there are numerous sources, so they're going to battle over this. So they're going to cite Webster's dictionary. Okay, not joking. Johnson's here. They're going to say this is what this means and so on and so forth. The judge is going to come to the conclusion that the statute and Trump's proclamation don't match. We located only one historical record from the debates over the AEA. They say Robert Harper moved to strike the phrase predatory incursion because he thought it was too expansive and too much power for the executive branch. And the Constitution itself also references invasion. And so we're trying to figure out what these words mean. But here, while the court finds that an invasion or predatory incursion must involve an organized armed force entering the United States to engage in conduct, the action does not need to be a precursor to actual war in order to qualify. So he's going to find that invasion or predatory incursion, it sounds like that element might pass. So he'll just kick it out on this next one. So then gangbangers say, well, maybe there's an incursion by Tren De Aragua, but it's not an incursion by a foreign nation. It's not an incursion by a foreign government. And Alien Enemies Act only says nation or government. Now, in advancing that argument, they say it's got to be something that has a territory or legal authority, and Tren De Aragua does not. Trump says, no way, it's more broad than that. Government is power or authority. Now, neither party claims that foreign nation or government excludes recognized countries like the US or Venezuela, and thus for reasons explained in the next section, we don't need to resolve this. It's unnecessary to resolve the issues in this lawsuit. Okay, so that's a little surprising to me. I thought that's where he would have kicked it out. So instead, he says, having determined that we don't know the meanings, the court considers whether as a matter of law, it exceeds the bounds of the statutory boundaries that the AEA establishes. The court says, yes, you did. So the proclamation is illegal because it's outside of the statutory requirements. Here's why. The court finds the proclamation places the government as Venezuela over the controlling entity over TDA. According to the proclamation, Maduro is involved in it too. And Maduro, who claims to act as Venezuela's president, leads the regime, which coordinates and relies on Tren to carry this out. Now, although the proclamation from Trump focuses on their activities, it places control of those activities in Maduro, acting in his claim role as president. In other words, it says Venezuela through Maduro directs Tren. And they accurately characterize the proclamation message, saying it's essentially Tren is indistinguishable from Venezuela, the state. Now, as a result, the court concludes the proclamation places responsibilities for Tren's actions on the Venezuelan government, which satisfies this. Now, as for the activities in the United States, the court concludes that they do not fall within the plain, ordinary meaning of invasion or predatory incursion under the AEA. So he says, in other words, in Venezuela, they're gangbangers down there, but in the United States, it's not necessarily an invasion or predatory incursion. Here's why. Now, no question, the proclamation references Tren coming in, saying they've unlawfully infiltrated. He says, yep, they're here. And these members include harming the United States. Got that too. Okay. And in addition, it also references the decision of the agency during Joe Biden to designate TDA as a transnational criminal organization and ongoing criminal activity and more. But those factual statements depict conduct by Tren that unambiguously is harmful to the society in this country. But he's going to keep him here. Okay. And as previously explained, the political question doctrine prohibits the court from weighing the truth of those factual statements, including whether Maduro is taking action. Instead, the court determines whether the statements taken as true are actually an invasion. And based on the plain reading, this court concludes that those factual statements do not. Wild. So Trump's written proclamation just doesn't allege enough facts to show an invasion. He says the proclamation makes no reference to and in no matter suggests a threat threat exists of an organized armed group of individuals entering the United States at the direction to conquer the country or to assume control over a portion of the nation. Wild! Did he forget about what happened in Colorado, where they took over apartment buildings? I wonder if he brings that up in here. Says, thus the proclamation's language cannot be read as describing conduct that falls within an invasion. So they're just like here on vacation. As a predatory incursion, the proclamation does not describe an armed group of individuals entering with a purpose to attack. While the proclamation does say that they've harmed lives, it doesn't suggest that they've done so in an organized attack. So this judge is dunking this on the form of the proclamation. Are you joking me? He's like, you just didn't write it good enough. You didn't satisfy my rubric. For these reasons, the court concludes the president's invocation exceeds the scope of the statute and therefore is unlawful. You don't have the lawful authority to do what you've done. And so here the judge finds, in conclusion, they're certified class action. They've demonstrated relief in habeas, and Trump cannot remove these people. Permanent injunction prohibiting Trump from employing the proclamation against any of these people. The certified class warrants similar protection. The court will issue a final judgment, and to the extent that anybody has been detained and they have not sought and do not obtain any relief, they say, in addition, the conclusions of the court do not affect Trump's ability to continue removal proceedings under the INA. Okay, so in other words, you can still deport people, but you just can't use the Alien Enemies Act to do that. Yeah, and in other words, these people can still be removed under the INA if there's validity to do that, because they're not seeking relief under the INA. But under the Alien Enemies Act, they cannot be removed. So signed by Judge Fernando Rodriguez Jr., the same judge who's given them ACLU lawyers and making sure they cannot be ordered out. Here's the final order. It says, all right, here, the class petition for the writ of habeas corpus is granted. Okay, so not only the 3 people who filed, Trump says, everybody's gangbangers, you're all going out. A couple people say, nope, you got me wrong. I'm not. I'm going to file my petition. Judge says, since you filed your petition, now everybody gets to stay and they all get the same writ of habeas corpus. So you cannot remove them under the Alien Enemies Act, saying Trump is permanently enjoined from removing them or anybody in this district based on the Alien Enemies Act. The permanent injunction does not stop them from removing other people under the Immigration and Nationality Act. You just can't remove them under the AEA. So they're going to be hitting that hard. You better believe this, baby. They're going to just double time those cases. This final judgment and permanent injunction does not enjoin Trump in his official duties as president of the United States, because you can't do that. That's why this judge squeezed that little thing in there. And it's like, all right, Trump should just go down and just approve every single deportation. Just load them onto buses one after another. You're on the plane, get on the airplane, fly himself. Choo choo, you're going home. All aboard the Trump train. And Fernando Rodriguez Jr., the judge out of Texas, is the judge who signed off on that. Now, as I mentioned, the judge is appointing the ACLU lawyer, Lee Gallant, the same judge who called in to another Texas judge and got scolded for it. You remember this judge posted the transcript of Lee Gallant, the ACLU gangbang lawyer, calling and screaming at the judge, basically. We'd like to talk to the judge immediately. Have the judge issue an order. Have him not moved. Judge understands. Like going nuts. And the judge scolded him for that, right? Issued that whole filing. Now he's going to be the same attorney who's doing unethical things in this courtroom, now palling around with Judge Rodriguez over there in Texas. Now, Stephen Miller came out today over at the White House. He was unhappy with what we're seeing in the media and in the courts. And here's what he was explaining to the folks in the press briefing room today.
It's a sad reflection on the state of our media and many of the outlets represented in this room that you obsessively try to shill for this MS-13 terrorist. Well, no coverage occurred in your papers about any of the Americans that were raped and tortured and murdered by the illegals that Biden was importing into our country. You know, you talk about due process. The Biden administration made the decision to give extensive due process to 2 Tren De Aragua terrorists that were apprehended at the border just a couple years ago. They were 2 gentlemen. They were from Venezuela. They were members of Tren De Aragua. The Biden administration Border Patrol apprehended them and made the decision to provide them with extensive due process, put them onto a program known as supervised release, and put them on ankle monitors so that they could go through a lengthy legal judicial determination as to whether these legal aliens who had just set foot on U.S. soil might want to live in the United States for the rest of their lives. What was the result of that decision? What was the result of that choice that was made? Those 2 men kidnapped a young girl named Jocelyn Ungary from her family. They beat her, they sexually assaulted her, they tortured her, they stripped her, they murdered her, and they dumped her body. That is what the Biden administration's policy was. Most of your papers never covered her story when it happened. To the extent that you covered it at all, it was because President Trump forced you to cover it by highlighting it repeatedly over and over again. He had to shame you into covering it. And each and every one of you that sides over and over again with these MS-13 MS-13 terrorists, to the extent that you have the financial means to do so, you all choose to live in condos or homes or houses as far away from these kinds of gangbangers as you possibly can. If I offered any one of you a rent-free home with no taxes to pay in any of these gang neighborhoods, and I said your neighbors are MS-13 terrorists or Mexican mafia or Sinaloa cartel or Tren De Aragua, I couldn't pay you to live there. But yet you, with your coverage, are trying to force innocent Americans to have these people as their neighbors, and that one day their daughter may be abducted from their home and raped and murdered. So you're not going to get an ounce of sympathy from this administration or President Trump for the terrorists who've invaded our homes and our country.
Yeah, and I couldn't appreciate that more, because this is just an appeal to emotion. I mean, it's a factual thing that's happening in our country where we're having innocent Americans getting attacked and abused. Even in the Kilmar case, right? He's beating his own wife, according to her, not me, twice, in 2 different order of protection filings that she submitted to the courts in her own handwriting, okay? So every time they come out and they lecture our side about, you deported a 2-year-old with cancer, how could you? Smack them back in the face, rhetorically speaking, with their own damages that they've caused to our brothers and sisters, our mothers and daughters, our friends and family all around us. And you may know people, right, who've had something bad happen to them as a result of the lawlessness in our streets. And so it is very refreshing to hear Stephen come back out and explain this to the media and remind them about what is actually happening. And if they want to appeal to authority all night, we can do the same thing, because the damage is reprehensible and it forces them to then backpedal into defending the gangbangers. And they're doubling down on it. Stephen Miller, I hope, keeps it up. We know he will. Shout out to the White House crew for laying it on thick to the media today. They deserved every bit of it. We'll see what the Trump administration does next with this case in Texas, whether they appeal it up or try something else. Whatever happens, we'll be here covering it. Thanks for subscribing and joining as we do.